Taking a second.
Working.
So there it goes. It's on. And we are live. If we can get there. And I will see if we can share this with people so people can find it. Here we go. So we're trying to figure out how to get this to go. So just a minute. All right, there we go. We have one person watching.
Just one person?
Right now, yeah. So we're trying to figure out. Ooh. So we got it going there. There we go.
Okay.
All right. So right now we're looking at it, and
so we're currently live on Facebook.
We are currently live right now. What time is it? We've got like 1 minute till we're supposed to start. There we go. And hopefully. Okay, so let's see if we can do this. All right, so let's see. Let me close this one right here. All right, there we go. Okay. Hi, Morgan. So do you see over there? So we're trying to teach Joel. This is Joel Borowiec.
Hi.
And he is a attorney here in Sierra Vista, Arizona. And how long have you been practicing?
34 years total. 23 years in Cochise County.
Okay.
Which is where I grew up. That's why I'm back here.
Right. Okay. And so you also have a sister that practices too, right?
I do. My sister is my partner. I had a brother that practiced with us also, and he died prematurely in 2004. And my dad practiced with us after he retired from the bench for about 3 years.
Okay. So your dad was a judge here in Cochise County too?
Correct.
Okay.
For 22 years, just about.
Okay. And so I, of course, have all this stuff popping up because I am not an expert at this stuff.
No, I'm lost.
So Joel and I have been going through this. He's never done this before. I have a couple rules that people have told me to follow. So I'm not supposed to say, I'm not supposed to touch my face. What else was it?
No swearing.
No swearing. What else?
That's about it, I think.
That's about it. And we're not wearing masks, but we're sanitized, and there's only us two and Ann in the building. So
we both drank a little Lysol right beforehand.
Yeah, and black coffee. So yeah, we should be healthy. So on the left, you can see people can make comments. So there's Morgan that said hi. So Morgan says hi.
Okay, this is all new to me. Hi, Morgan. How you doing?
So then they can ask us questions, but and I'm not sure if we can see how many people are on there watching right now. But anyway,
well, actually, there's a reason why we're doing this, and that is because you're running for Justice of the Peace in Cochise County Justice Court Precinct 5.
That's correct.
And as far as justice courts go, that is the 5th busiest justice court in Arizona. It's a little surprising for a lot of people, but it's true. Cochise County has 6 justice courts. We have one in Sierra Vista, Bisbee, Douglas, Benson, Wilcox, Bowie. Was that 6?
Did you get Douglas?
Yeah, Bisbee, Douglas, Benson, Wilcox, Bowie, and
Sierra Vista.
Sierra Vista, yes, of course, Sierra Vista. But this is the busiest one of all, of course, and has been for quite some time. And as we know, most people know that Tim Dickerson was the Justice of the Peace in JP5 for, I don't know, about 13, 14 years. And when I forget, I get confused. Who retired? Was it Elledge? No.
Oh, yeah. Yes.
Elledge's retirement. Yeah. Carl Elledge retired. So when that happens, the governor gets to appoint a judge. And the way it works in Arizona, if you're in a county of less than 250,000 people, the Superior Court judges are elected. In the three counties over that, which are Maricopa, Pima, and Pinal counties, Pinal now, that's really grown. In those counties, the governor always gets to appoint the Superior Court judges. Otherwise, in the other counties, except for Pima, Pinal, and Maricopa, the judges are elected. But when a judge doesn't finish out a term, the governor gets to appoint. So Tim Dickerson was appointed to fill the Cochise County Superior Court seat that Carl Elledge vacated. And that left Justice Court Precinct 5 open. And of course, Pat Call got that appointment. But as I understand it, he is not going to run in this election. He hasn't filed. And Christina, you're of course running for this seat.
Right.
And, I practice in Justice Court 5 quite a bit, mainly criminal, but the Justice Court handles several different matters. They handle misdemeanors. In the criminal side, they handle misdemeanors. They also handle felonies if there's going to be a preliminary hearing. There's two ways to charge a felony, right? One is the police arrest you, take you to jail, and you get released. However, the judge decides to do it when you make your initial appearance, whether by bond or your own recognizance. But then the police have to file the charges within 48 hours, and the Justice Court sets a preliminary hearing.
We'll drop that down. There we go. So
anyway, so in my experience, I haven't done a lot of preliminary hearings in Cochise County because that's one way to charge a felony. You go through a preliminary hearing and the Justice of the Peace can make a finding as to whether there's sufficient evidence for somebody to go to Superior Court on a felony charge. Otherwise, the other way to do it is by grand jury indictment, which is usually the way it goes in my experience. But the preliminary hearings are a big deal in Justice Court, and the procedure is kind of different in those because it's not like a trial. I mean, the state, the prosecutor gets to put their witnesses on, but the defense doesn't get to put any witnesses on. Although the defendant's lawyer can ask questions of the witnesses that the prosecution puts on. And then the judge, Justice of the Peace, would make a determination as to whether there's probable cause or not for that person to go to trial on a felony.
So
right?
yeah, no, that's correct. And the rules of evidence, they'll still apply, right? And the prosecutor has to lay a foundation and all that stuff, right, to get stuff in.
Correct.
Stuff. I keep using the word stuff. I'm so professional. We should say hi to everyone that's saying hi though. So Allison Essery said hi. Sharon says hi. Robin says hi. So hi. So my question for you is, so that makes me think, like, what is the most serious, like, type of criminal charge have you brought up in Justice Court?
Justice Court?
For like a preliminary hearing, I guess.
First degree murder.
First degree murder? When was that?
That was in 2001 or 2.
And how long did that take? How long was that?
The preliminary hearing lasted a full day.
And the Justice of the Peace presided over that?
That was Mike Herbelich, who was a lawyer in Cochise County for many years, practicing out of Douglas, and he had become the Justice of the Peace in Douglas. So he was a lawyer, of course, and he handled the preliminary hearing in that matter.
Nice. So then there's a probable cause finding as to whether or not that defendant committed first degree murder, essentially.
Well, there was a probable cause finding by the Justice of the Peace, Mike Herbelich, that my client should be, there's probable cause for my client to stand trial in Superior Court for first degree murder. We appealed that ruling to the Superior Court, and the case was dismissed.
So as a criminal defense attorney, and I said again, my son TJ's tallying all the times I say during this, so we'll see. But so what happens after, that they get sent up to Superior Court, correct?
Well, yes.
Yeah, and then you deal with them up there, right?
Right.
So you said that it got appealed. So what to you makes it important for a justice of the peace to have like experience in the law and have experience with like legal research and writing and that sort of stuff, as far as in like how an appeal goes and all that?
Because these are serious matters, and if the justice of the peace isn't experienced, either as a lawyer in the practice of law and criminal law, or justices of the peace don't have to be lawyers in Arizona, but many are, and mostly in the bigger counties, Maricopa, Pima, and Pinal County. I think the bulk of the justices of the peace are lawyers. I'm not totally positive about that, but those are the ones I've run into in those counties. But yeah, you need somebody able to make that judgment. First degree murder is a big deal. I mean, that's a class 1 felony. That's the highest felony somebody can be charged with, and the penalties are, potentially life in prison without parole.
And even if they're found not guilty later, or the case gets dismissed, it permanently stays on their record, doesn't it?
Yes. Arizona, unfortunately, does not expunge criminal records. That means if you're charged with something, and even if the case is dismissed, it'll always be on your record that you were charged with something and the case was dismissed, even if you didn't do it. And that record can never be erased or expunged in Arizona.
So even if your client was found not guilty, I'm going to be able to do a background check on their employment and still see, hey, he was charged with first degree murder, and
right.
Of course probably won't hire him because they were once charged with first degree murder.
Right. Well, there is actually one procedure that you can do to take a matter like that in Superior Court and have the judge determine that there was no substantial or no real basis for the charge, and the judge can order all of the records sealed. But that happens very, very rarely. And so you have some questions here?
I think there are just a couple of people sending me messages trying to figure out how to get on there. So over here, I don't see any questions yet, or maybe we do. Let
me ask you, how long have you been practicing, and where have you practiced?
So I have been practicing law for 11 years. For the first 4.5 years, I did private practice. I did criminal defense. I did family law. I did landlord tenant. I did defensive protection orders and harassment orders. Some landlord tenant wills and trusts. Did some collections for a couple of chiropractors and stuff that were trying to collect on their bills and things like that. So that was civil, smaller claims. Then I did juvenile court there too. I was a guardian ad litem and I was a parent attorney. And so I came here to Cochise County in 2013. I've always been licensed in Arizona. I've been licensed here since 2009, but I came here in 2013 and joined the county attorney's office. And I worked there with the exception of 1 year. I went to the AG's office and did dependencies. But I did.
And the AG people may not know, it's the Attorney General's office, right?
Right.
It's higher up the ladder than the county attorney's office.
Kind of, yeah.
No, it is. It's the state's attorneys, basically. Even though the county attorney's office, the county attorney is elected and hires the lawyers that county attorney wants to hire, and they can prosecute any case, first degree murder, the highest felonies through, any felony. But the Attorney General's office is like a step up because they handle the entire state.
And complaints too against county attorneys.
Complaints against county attorney's office. Right. They handle complaints against police officers a lot of the time, and they also represent all of the administrative boards in Arizona, like the chiropractic board, the board of appraisals, the real estate board, BOMEX, the medical board,
right?
The behavioral health board. POST, the Police Officer Standards and Trainings Board, the Liquor Board. There's a plethora, many administrative boards that regulate all of the professions that require licensing, and a lot of the licenses that are specifically required that you have to be sanctified or licensed by the state to do whatever it is you do. There's probably an administrative board that handles that.
Right.
But the Attorney General's office represents all of those boards in Arizona.
Right. So see, he's super smart.
I don't know about that.
He's super smart. We have a question Do you want to sidetrack and answer the question?
Sure. What's the question?
So it said, would it save taxpayers money to have a JP, so a justice of the peace, who knows the law and the proper procedures to follow in the court?
Yes, it would, because it saves time, first of all, because if you have a justice of the peace that's experienced, they can dispense with more matters more quickly because they've been there. They know what the law is, that they don't have to go look it up. They know what the procedure is. So it can just go very rapidly. And that's what Judge Dickerson did when he was in JP5. He was a lawyer before that in private practice here in Vista, and you can handle a lot of cases in a short period of time with the experience, of being a lawyer and having practiced.
And you were talking about JP5 being super busy, like fifth busiest.
It's the fifth busiest justice court in the state of Arizona. I know it's hard to believe. It's busier than a lot of the justice courts in Maricopa County, Pima County, Tucson, and Phoenix. It's just a very busy court.
And you practice in JP5 right now?
Yes.
And
I have been since 1997.
Okay. So there's like 14,000 cases filed in JP5 a year. I think we said, how many thousand were
I think about 7,000 were criminal.
Yeah.
They're not all misdemeanors. I don't remember what the felony count was, but it was, I think, 1,100 or something.
Yeah, but I think it's about 2,000 felonies are filed, and I think 4,000 misdemeanors are filed, and DUIs and all that. So, how when you come in on and do pretrials and represent defendants, right?
Yes.
Why? So 2 questions on that. Why do you still practice in justice court, and why is it important for you, to help your client not be convicted of a misdemeanor offense or help them get the best deal or whatever? Why do misdemeanors matter?
Well, it goes on your record forever, first of all. And secondly, if it's something that involves dishonesty, you really don't want that on your record, especially if you didn't do it. A lot of people will take a plea agreement because they think that it's easier and cheaper than hiring a lawyer, and that may be true, but then you have that on your record. And for other criminal charges, there are repercussions that go way beyond just the penalty in the court. In other words, if you're convicted of domestic violence in a justice court, or you plead guilty to it, there's an impact on your ability to own firearms. And you actually are required to turn your firearms over to the sheriff's department. Right.
And then getting onto base, can't get the security clearance, things like that.
No, that interferes with everything.
Yeah.
I mean, people that are in the military can't carry a gun, so they can't, function as a military member. The repercussions are pretty broad.
Right. And with DUIs, they lose their license and all that.
Yeah, with the DUI, depending on there's 3 classes of DUIs. There's a regular DUI, there's the extreme DUI, and what they refer to as a super extreme, which is over 0.20 in terms of the alcohol concentration in a person's blood. 0.08 is the initial level at which you're considered intoxicated. And it goes up from there at 0.15 and over. You're an extreme at 0.20 and over you're super extreme. And the penalties change for each of those, but they're a 2-part case. There's the part of the case that deals with the ADOT, the Arizona Department of Transportation. It deals with your license, because your license is suspended automatically 15 days after you're charged unless you request a hearing in front of the Arizona Department of Transportation. Then you also have to deal with a criminal matter in the justice court. And for a regular DUI, if you're convicted, you'll get a 10-day sentence that usually suspend 9 days. So you do basically 24 hours in the county attorney's office. The fines are a little over $2,000.
County jail, not the county attorney's office.
Yeah, well, I'm sorry. I
and I touched my face. I touched my face.
Oh, don't do that.
I got one touching my face.
It's 24 hours in jail. It could be 10 days, but mostly it's 24 hours because the judge is allowed under the law to suspend all but that 1 day. And like you said, the fines are a little over $2,000, about $2,200. An extreme DUI, the fines go up to about $3,500. And
more jail time.
For an extreme DUI, it's 30 days. and the judge can suspend all but 9 days. So you'd have to do 9 days in jail, in the county jail. And for a super extreme, it's 45 days in jail, and the judge can suspend all but 14 days. But those are straight days, no breaks. But sometimes you can get them to do work release or something, a little fudging with the lines there. But, the DUIs are bad because people lose jobs, they lose their ability to drive. And one of the penalties is loss of your license for a regular DUI for 90 days, can't drive at all for 30 days. After that 30 days, for the next 60 days, you can drive to a limited extent to go to work, to go to doctor's appointments, to go to school. But you have to get an ignition interlock device on your vehicle, and that's the only vehicle you can drive.
Right.
And after you get your license reinstated, the Arizona Department of Transportation will require you to have that ignition interlock device for at least 6 months. And that costs about a little over $200 to get it installed, and about $80 to $100, depending on where you go, per month to have the thing calibrated every month.
So essentially your life is owned by all these restrictions and all this other stuff for longer than just one day in jail. I mean,
Right.
You've got all this stuff that you have to keep going through.
Oh, it's one of the most severe penalties in the country in Arizona for driving under the influence. It's a very bad thing to do.
Right.
Employers don't like it. You won't get a security clearance with it. It's become a very bad thing.
So we have some questions. So Chris Russell asked right up there. Let's see. Chris, I think, also practices in JP5, but he said, "What do you believe is the most common types of cases that go through JP5 that affect our citizens?"
The most common type with the biggest impact on citizens are the misdemeanors.
Yeah. And which type do you think of the misdemeanors?
Well, the DUIs are bad and the domestic violence are bad. Both those two categories of cases have very serious repercussions that go beyond just paying a fine in the justice court. They're much more serious than that.
So then Sheehan Daly asked, some people say that plea bargains are bad. What is a plea bargain and how do they help the system?
Plea bargains help the system because when you hire a lawyer, this is my view, my opinion. When you hire a lawyer in a case, usually the county attorney's office is going to deal with that lawyer, and depending on the type of case, usually you can come to a settlement that's less than what's actually charged, or DUIs are a different category because then you really have to have a basis to get the charge either thrown out or diminished. But normally you can bargain for a lesser charge, and that's what you get with a lawyer because, frankly, the county attorney's office cannot afford to hire enough lawyers to try every case if they had to try every case. So that's how plea bargains help the system, is they clear out the court calendar and they give people an opportunity to choose their punishment, as it were, and people know if they're guilty or not, if they did something or not. And so those cases basically where the person believes they're innocent or have to go to trial for some other reason, those are the cases that go to trial. The rest of them get plea agreements, and it makes the system run more smoothly and more quickly and saves time in court and time for the county attorney's office.
Well, and sometimes we can give I'm the prosecutor in JP5. Sometimes we do diversion, have them do a class or something, and it can be dismissed, which if it goes to trial, can't do diversion or
Correct.
Work it off. So if they're found guilty at trial, it's a guilty finding versus if they happen to be a one-time thing, can possibly do something to work it off, do community service or something. Would you agree with that?
Yeah, if you can get adult diversion, you work with the diversion officer of the county attorney's office. I said, sorry, said it again.
He said, I'm not the only one that says
You work at the adult diversion section of the county attorney's office, and it lasts for 3 months. It costs you $500 to get into that program. You have to file a form every month delineating or telling the office whether you've had any contact with police or committed any other crimes or anything like that. And if you haven't, and usually you get 20 hours of community service with that you can do for any 501c3 nonprofit charitable organization. And they have a list of some of those, like Salvation Army or something like that, or a church. And then your charge is dismissed at the end of that. So it's an alternative to getting a conviction. Sometimes if diversion isn't appropriate, the county attorney's office will do a deferred prosecution where they just hold the matter in abeyance. They don't do anything with the case. If you obey the law for 3 months or 6 months, whatever you agree to, then they'll dismiss the case after that. But again, it's always going to be on your record once you're charged.
And I was thinking about how you were talking about pleas. Sometimes too, like if someone's charged with like 6 counts of something, they could do a plea to just 1 count if it's necessary. So then they only have 1 guilty instead of 6, right? And also thinking about diversion, usually a justice of the peace, if they find him guilty, they could put him in jail or they could give him a fine or whatever. But diversion is actually a lot more work than just a fine. Wouldn't you agree?
Well, yeah, you have to do the 20 hours of community service and pay the $500, but you got to keep track of it for 3 months and report to the diversion office, the adult diversion office every month. And yeah, it's more than just writing a check or giving them a credit card for a $300 fine. It's $500. Plus, you have to take a class in something that's going to cost about another $120 or so.
The online workbook.
Online workbook.
Right.
Thank you.
Well, and then the other thing on the plea bargain thing in JP5, we have like 90, right now we're calendaring about 95 a week on those pretrials. So it's like almost impossible to have enough justices of the peace and attorneys to do 95 trials in a week. What do you think?
It'd be impossible.
Right.
The system would just come to a stop.
Right. So, so then someone asked the question, what are the pros and cons of having a legally experienced JP5 than say just someone off the street? Like just saying they don't have any legal experience, but they don't need it because the law doesn't require it.
Well, yeah, at least as we discussed, you don't have to be a lawyer to become a justice of the peace. However, a lawyer has been to law school, and that's a great step up because they can at least know how to do the research and everything. But even better than that is somebody that's practiced in the justice court, in the court that they're going to be the judge in, because then they realize they know how the system works. And if you know how the system works, but more importantly, know the law, you can make things go much more quickly. You're not sitting there going, gee, what do I do with this? I haven't seen one of these before. You're going to know what to do, except in the strangest of circumstances. And things do come up and legally that nobody knows what to do with.
Right. But, well, I was thinking too, how does if you don't know how to deal with something or know how it could affect something else, I mean, if they allow someone to plead to something and they don't realize that they may have rights and advise them of the right rights, or say maybe you should wait, for example, like people that are on felony probation, or maybe have a pending child custody case, right? And you plead guilty to disorderly conduct. There are consequences in other areas of the law or other courts for those as well. Is that right?
Right, yeah.
And felony, I mean, if you plead to disorderly conduct, for example, and it's part of a PTR felony court, you could end up in prison, right? So it's more than just a fine. You might end up in prison for years. Would you
True.
Agree with that?
Yes, of course. And if you don't have a lawyer, sometimes the justice of the peace will help you in doing basically what's a short version. There's a thing called a Donald hearing that they do in felony cases, where you go before the court and the court goes through each of the charges that you have been charged with and tells you what the possible penalties are in terms of jail time, prison time rather. Fines are, of course, much bigger in Superior Court, but a lot of times the fines are less than the maximum could be because these people can't pay it. A lot of them, most people can't, but they let you know what the possible penalties are, and judges in the Justice Court sometimes do that for people that aren't represented, and tell them, look, maybe you should hire a lawyer here, maybe you should plead not guilty, something like that, because they know what the severity of the impact is going to be on the person. So having somebody that knows the law behind that bench, as the judge, is a great benefit to the society, to the community as a whole.
Right. Someone else asked, How important is it that a justice court judge know how to properly do legal research? I think you kind of touched on that earlier, but you want to just briefly touch on that again?
Sure. Well, legal research is basically just finding out what the law is, and there are a lot of resources for doing that. But you have the state statutes to deal with, the Arizona revised statutes, and you got to know where to go to look at those laws because they're broken up into sections, but there's like 48 books, I think, in the Arizona revised statutes, and just 4 of them deal with nothing but criminal law. But you have to know where to look, and you have to know what things mean. And a lot of times, if you run into a hearing in the justice court, if you're arrested and you believe the arrest was improper and the evidence was improperly obtained, you can file a motion to suppress. And in that situation, the judge should really know the law because that's a very important issue. If the arrest wasn't proper or a search wasn't proper, the judge really has to know what the law is. I mean, the lawyer, if you have a lawyer, the lawyer will try to tell you what the law is, but the judge should know independently what the law is in those situations so that they can make a correct ruling, because otherwise they go up on appeal in Superior Court, sometimes going to the appellate court, and it just wastes the state's money and resources if it's not done correctly.
We've done suppression hearings against each other, right? Some briefs. I think we've done one that had to do with a crosswalk. We did briefs. I wrote a brief, and
I forgot about that.
And that had to do with, like whether or not the stop was justified or not. And, you held a hearing. I wasn't the one that actually did that hearing. That was a different prosecutor because I don't remember why I didn't do that hearing. I think I had just come back from Nebraska, but you ended up winning that suppression hearing. The judge had done legal research, and he actually did a memo, didn't he? And he laid out what his finding was and used case law and said, that the traffic stop wasn't legit, right? And it violated constitutional rights. So ended up the evidence wasn't able to be used, correct?
Right. And that winds up in a dismissal of the charge.
Right.
But yes, that was Judge Dickerson. And yes, he wrote a great opinion.
And you've used that opinion since, right? When you're negotiating stuff or,
Yeah, I refer to it. I mean,
right.
But, you know what the law is, and so does the judge. But sometimes there are arguments, and the facts are the things that make a difference in those situations. So the judge has to look closely at the facts and know which facts are important, because not every fact involved in an arrest of somebody, in this case for a DUI, has importance. There are certain things that do and certain things that don't mean anything, and the judge has to know the difference.
Right.
So yes, being able to do legal research is really, really important.
So someone was asking, going back to plea bargains, do plea bargains ever help a victim in any way?
Yes, I think they can, because if there's a plea bargain under the victim laws, there are laws established to protect victims and provide victims with notifications of hearings, trials. In the county attorney's office, you have to consult with the victim,
right,
before you enter a plea with somebody, correct?
Right.
And what the victim says can have some impact on what the plea is.
Right.
So if the victim says, no, I can't agree to that plea, that has some role in the decision making of the prosecutor. Right?
Well, I mean, it does. I mean, you have to take that into consideration, but you're also remembering you have to advocate for the law, and if you can't prove it, and you have to take that into consideration anyway. But there's also that flip side of whether or not the victim even wants to testify.
Correct.
Because then they sit on the stand and someone like you drills them, right?
No, it's called cross-examination.
Cross-examination, well, of course. But like for the average term would be like you're drilling them, right? You're trying to talk to them. And I don't mean to drill. I'm making Joel think I'm picking on him. But Joel ask him a bunch of questions that maybe like, if it's a younger victim or it's a more timid person, they might feel, like scared to go up on a stand, or they don't want to do it and they just want it over with and they want it past them, right? And they don't have to sit here and go through a week-long trial or 2-week-long trial. You can take care of it and it makes them, they're satisfied.
If the victim is agreeable to whatever plea is offered, then the matter just goes ahead and it's over, and the victim doesn't have to worry about testifying or going to court to testify at a later time. I said, it can help the victim in a lot of ways, and a lot of times in a domestic violence situation, it's unfortunate, but it happens in a marriage or a relationship. Two people really do care about each other, but something blows up, or somebody has too much to drink, or something like that, and there's an argument, maybe just an argument, somebody breaks something. That's domestic violence, criminal damage. It can even be your own thing. You could get angry and in an argument with your wife or husband or whatever, and pick up your TV and smash it on the floor, and you can be charged with domestic violence, criminal damage, even if it's your TV.
Right. We've had that come up a lot. People ask, how is it against the law for me to break my own stuff?
Well, it is. I mean, I think what the law considers that's a demonstration of anger and force, and it can intimidate people, and that's what the law is trying to prevent. I think in those situations. Do you disagree with that?
No, I agree. I have that conversation with people almost every week. I mean, when we talk about it, and then, I mean, depending on what we do with the case, how I'm doing.
Well, and like I said, if two people really care about each other,
right?
Sometimes this is a one-time thing, and it's a learning, it's an educational issue for both people in the marriage, that you can't do these things. But the victim, the wife or the husband, whoever didn't do the breaking of the property or whatever other act constitutes domestic violence, can say, gee, I really don't want my husband punished, or I don't want my wife punished for this, and can talk to the prosecutor and say, what can we do?
Right.
And depending on the severity of what the crime was, sometimes you can do diversion on those things, or a deferred prosecution, right?
Right. Usually
or even a dismissal.
Right. Usually what I've been doing is have them do the anger management course. I think we've had some of your clients do it, other people's clients do an anger management course or a domestic violence course, and learn that cycle. And hopefully then they learn their lesson. It's just a one-time thing. I think the thought process behind not just dismissing everything is, for the repeat, sometimes they get in a cycle and they start repeating, just calling and calling on each other. You need to understand that it's serious, and you're not getting trapped in that cycle where you're going to be just keep committing domestic violence and think it'll be dismissed every time. The other thing that I think that brings to mind is some people have said, I wasn't violent. How am I getting charged with domestic violence where it's just an argument and it's the domestic violence disorderly conduct? Well, I didn't hit her, or I didn't break anything. We just were in an argument, but the neighbors called them in or whatever,
Yeah.
They don't understand that that's domestic violence, considered domestic violence in Arizona, and I didn't punch you, but we were arguing, so it's domestic violence disorderly conduct, and they don't understand that because they think violence has to be where you're actually hitting each other. And so
or
they
domestic violence disturbing the peace, right?
Yeah. Well, that's the disorderly conduct disturbing the peace.
Yeah.
Yeah, that's the one. So, or the court orders, but, so yeah,
and that tells you just how intrusive the government is into people's private lives, because you can't even get excited or angry and yell something, even if it's not mean, but just, why did you do that? If the neighbor calls the cops, potentially you could get arrested for that. I think it's a little too far, but the pendulum swings back and forth. I've seen it change over the years, and I said again. I've seen more changes in rules and regulations in the law in the last 10 years than I did in the first 24 years I practiced. It's amazing. And we now have rules of protective order procedure, rules for the basically civil rules of procedure for the justice courts in civil cases.
Mm-hmm.
That's new.
Right.
Lots of rules have been changed. But that's why lawyers don't practice in all areas, because it's impossible to keep up with it all. But
we're trained how to look it up and find it and learn it, right?
You can, but for a lawyer, it's really dangerous if it's something that's complicated and you haven't done it before.
Like quadros or rules against perpetuities. Just kidding. That was me being funny.
I don't know why that rule is so difficult, but people think it is, and that's a rule that you don't need to know about. Rule against perpetuity.
Right, rap. Only people that have been through the torture of law school understand what that
Well, it has to do with inheritance, and
right.
it's like in a will, you can't give something. You can only give something to what is it? Life in existence, life being in plus 21 years. Is that the limitation on it?
Something like that. I don't know. There was a whole bunch of them. Professor Medill gave us like all those examples and everything, and that's why I didn't pursue.
Well, it can be difficult enough that it's the one thing you cannot be held to a malpractice in screwing that up.
Right.
Do you know that?
No, I didn't know that.
It's pretty funny.
I'm not as smart as you are. No, I'm just kidding.
Oh, yeah, you are.
So
you pursued a different path. I do a lot of civil work as well, but you wound up doing. You've got civil experience, several years of it, but you wound up doing prosecutions basically for the county attorney's office, right?
Right. I like what I do. I one of the things I like. I know you haven't done a lot with care court, but I like care court. And when I see a veteran, especially coming through,
you should explain it to people. What is care court? And it's an acronym, CARE, CARE.
Yeah, community. Oh, I forget what the A stands for now on the spot. Response something. Community. Well, it's essentially what we're doing is getting help for people that have either mental health, substance abuse, or or a veteran track, and we're getting them help. So, for example, if I have a veteran that's come in and has like PTSD, well, they've served our country, and we can get them help. And we've got the Warrior Healing Center has come in into care court since I've been back, and they've graciously, they're local here, take the veterans in, and they're bringing them in and getting them used to the community again. And we had someone actually say they were a godsend. So instead of getting them a conviction on their record, they're getting some help either for PTSD or whatever the issue is, and then they get a dismissal. So it's kind of like, what's the point of fining everybody if it's something we can get them help for, and then they won't do it again? I mean, or like, sorry, a homeless veteran or something that goes in and steals a flashlight or something. We can get them hooked up with one of the centers, the VA or the Warrior Healing Center, and they can get housing and get back on their feet and get a job, and they're now a productive member of society again if they're willing to engage, of course. But Allison told me court-assisted recovery. It's court-assisted recovery. She looked it up for me.
Oh, we got a question from Chris Russell, who is a local lawyer here in Sur Vista, and he said, "I sit on it. I guess they can see that question at home, can they?"
I don't know what it looks like at home, but
well, let's see. He says, "I sit on the state bar's rules committee, and the rules are constantly changing. How important is it that a justice of the peace know that the rules are constantly changing, and going from memory or shooting from the hip is detrimental to all involved?" Well, I can answer it quickly. If you don't know what the rules are, you're gonna make a mess for somebody that they shouldn't have to have. In other words, if a judge makes a bad decision because they don't follow the rules and it has a serious effect on the person's life, the person has no alternative but to go up on appeal, and that should never happen. The rules do change all the time. And I mean, as a lawyer, and then right now you read the rules constantly.
Right.
You have to.
Yep.
Because they change all the time. So every time I run into a particular statute, I always go and read the statute, because you never know if there's going to be a little change or a new case affecting it.
Right. No, they'll change one word in a statute that makes it different from one year to the next. And sometimes a defense attorney will point that out to me, they'll be like, oh, that changed, or the consequences have changed, or whatever.
Or case law comes down from the appellate court or the Supreme Court and say, okay, we've considered this aspect of such and such a criminal statute, and that's not what it means. It means something else. But you have to know that. Well,
and right now the marijuana is always changing. It seems like right now, you agree the whether or not there's probable cause to believe, whatever it is, and the medical marijuana cards have come out, and then there's been different determinations as to whether or not just the smell of marijuana is enough to search vehicles or houses or whatever. And then that comes into play in justice court because we do the possession of drug paraphernalia and possession of marijuana in justice court. So if you had a case like that and you wanted to suppress the evidence, you got to be able to look up the most recent, case law so that you.
As a lawyer, yes.
Yeah.
But as a judge also, and that's another function that the justice of the peace has, is that they actually issue arrest warrants. The police will call them in the middle of the night and say, over the phone and say, hey, we need a warrant to search somebody's house because we believe this is going on and here's why we think that. And the judge can then issue a warrant over the phone, give them permission to go execute a search warrant and search somebody's house or vehicle or whatever is required. And if the judge doesn't know the law, that too can make a mess for somebody. And just having a judge that's acquainted with the law, that's been to law school, I think is a great benefit. Yes, we've got good justices of the peace that have been there for years and have learned, and they know what's going on and they know what to do. But it takes a long time to gain that knowledge. That's why people go to law school.
Well, and sometimes those, going back to what you're talking about, those search warrants, they're at 1 and 2 in the morning sometimes, aren't they? And the DUI search warrants and the house search warrants, all that is sometimes in the middle of the night, right?
That's one thing that happens frequently is that if you're charged with driving under the influence and you refuse to take the breathalyzer, the police can then apply for a warrant to draw your blood. And they have to wake up a judge somewhere, usually a justice of the peace, and get a warrant over the phone to draw blood. And they have their own phlebotomists. Phlebotomists are people that draw blood. They're trained to draw blood. Don't have to be a nurse, but you do have to go through the training to draw blood. And that's not a good thing to do, is refuse the breathalyzer, because they will hold you down and draw your blood if they need to.
And that's a Fourth Amendment search of your person, right?
Correct.
Right.
It requires a warrant.
Right. So I don't know if we have any more questions. We've been on here for 47 minutes. Does it feel like we've been on there for 47 minutes?
No.
So Joel and I were worried what we were going to talk about and everything. We decided to do this unscripted. So I don't know if we missed any questions. Let me see if we missed any questions. Okay, we'll do one last question. So it says, what's the difference between a misdemeanor trial and a felony trial? So like jury trials probably, and do the same rules apply?
Yeah, there's very little difference in the rules. If you're doing you can get a jury trial only in some situations in justice court. One of them is for a DUI, you're entitled to a jury trial. And I don't want to get too complicated here, but for any crime that was a crime under the common law prior to statehood, you can get a jury trial for.
Right. And so justice court was got like the thefts and shopliftings and stuff. We can arguably still get a jury trial for.
Correct. So there's not a lot of jury trials done in justice court, but the felony trials in superior court, of course, the stakes are much bigger, and the trials usually take longer, and there's more police involvement. The county attorney's office, of course, has to present the case, and you've got a jury of 8 people, 12 if it's a murder case. And in justice court, like Christina said, there's DUIs and maybe some theft cases or something like that, which are entitled to a jury trial in justice court.
So same burden of proof?
Yes.
Right. And same rules of evidence?
Yes.
Right. So, and then the judge is the one that puts everybody in check, if you want to use that slang, but they're the ones that run the courtroom, right? And say what can and can't be entered and whether or not this objection should stand or whether this exhibit should be entered into evidence. Yes. And that's
the judge's biggest job in a jury trial is they're like a referee. The judge will tell somebody that somebody tries to get some evidence in that's improper. The judge will cut that off and not allow that evidence to be entered. And they try very hard, the judges do, to make it so that the jury doesn't hear about things they're not entitled to hear about or consider. And the judge has to know the law, especially in justice court, I think, so that evidence that isn't admissible doesn't come in, and that evidence that is admissible is allowed in. But you have to know the rules. You have to know the case law, uh, and the rules of evidence. And some of these issues are not easy, not even for lawyers.
Right. I touched my face while you were talking.
I wish you wouldn't do that.
I know. I'm like, I know my son TJ's tallying up how many times I touch my face and how many times I say I was trying. So
I'm glad somebody's counting.
right. We'll tally them because we'll have to tally how many times you say I'm sure I've outdone you with mine. But.
I say once in a while, and people that say that, a lot of judges do that too. It's just people say that because it's kind of like a break, and their brain can catch up with their mouth or something like that.
Right. Well, I had a grand jury script once. A defense attorney had brought it up and did a motion with my grand jury transcript, and you could see the ums. So that was when I was like, oh man, I got to stop saying so much, and tried really hard. But
I had that problem when I was a young lawyer. I would, in a jury trial, somebody answered a question in a deposition, and they finished their question. I go, okay, now,
so then you have like 800 okays.
Yeah, that's not good. That's not good. Well, you have to be more precise with your language in jury trials and in trials generally, because how you say things impacts the meaning, of course. And when these things are written down by a court reporter or they're recorded in justice court, and you have a court reporter transcribe those if you go up on appeal, what you see on the record does not reflect what somebody's face looked like or what their expression was, or whether they looked like they were not telling the truth or they got nervous or something like that. It's just words on a page. You can be yelling and it's just words on the page. They don't put in there so-and-so was yelling and he said, they don't do that. It's just words on a page.
Right. Or exactly what they see in front of them, what the actual exhibit actually looks like or where it was.
Correct.
So, well, I think we're good. I think we've probably taken up enough of everybody's time. Oh, there's another one. Let's see.
Sandy Russell has a question. She says, how important is involvement and membership in local bar associations and other lawyer organizations and CLE, which are continuing legal education classes, in keeping up with the law? And what is the difference between lawyers and lawnmowers on CLE, continuing legal education questions, and keeping up with the law? Well,
it's like a compound question there.
It is.
Just kidding.
It is. Membership in local bar associations, I don't know. I don't really participate in that stuff. But
what about just like continuing legal education? Lawyers have to do how much a year? Do you remember?
15 hours a year.
Right.
Every year. And you have to report by a certain date. And if you miss it, then you got to pay an extra $100. And if you miss the next deadline, and it's $200. And if you miss it by December or something, then they really drop the hammer on you.
So we still have to keep doing our education and stuff. I think last year, the year that I was working at the Attorney General's office so I filed it in July. I'm 96 credits. I'm overeducated right now, I think. Too bad I can't just span out.
Well, you can carry everything over for 1 year.
Right.
But no, you can't ever know enough, or know too much, rather, I should say. The more you know, the better off everybody is when you're the judge. Right,
to keep your licenses though too as an attorney, and then when you're the judge, if you know what's going on, it helps, right?
So it does.
Never know if there's going to be attorneys that blindside you. Just kidding.
No, the judge again has to run the courtroom. The judge tells the bailiff when to take the jury out, when to bring the jury in. The judge runs the entire courtroom, and you got to have it's like driving a team of horses. Maybe that's a bad analogy, but the judge holds the reins and controls where things go in terms of time, in terms of when the jury should be in there and when they shouldn't be in there. The judge gets in justice court. I think the judge swears the witnesses. Yeah, that's right?
In justice court?
Yeah.
Pretty sure it's the justice was doing it. I thought the clerk did it, but no.
But if it's a court trial,
the justice.
It's the judge.
Yeah, it's the justice of the peace.
That's where it is.
Yeah.
But the continuing legal education programs, as much as they're a pain in the butt for everybody, lawyers, because it's 15 hours that you have to spend taking these classes, and you resent them, but you also look and you find stuff that, hey, that's an area that I practice in, and there's always something new coming up.
Right.
And I find that they're very helpful a lot of the time.
They are. They'll do year update and reviews for the criminal law and let us know what we should be paying attention to if we missed a Supreme Court opinion or something and all that good stuff.
And do the judges have continuing legal education as well?
They do have judge court. The justices do like 3 weeks. They're split up throughout the year. But I don't think they have the continuing legal education
Right.
requirements like the lawyers do. So I would have
Initial training program.
Yeah, you have the initial training program, and that's going to be like how to process everything, but they're not going to teach you all the stuff that we've learned all those years in law school and stuff. I mean, that took 3 years.
Yeah.
You know what I mean? So, I almost touched my face again.
It gets complicated, and having a lawyer on as the judge is better. And I've read this several times, but since 1962, the number of laws, rules, regulations that affect our society have quintupled. That means we have 5 times as many laws, rules, regulations that we had in 1962. And that's amazing. There are like 4,500 federal criminal statutes, and nobody knows them all.
Right.
The statutes in Arizona, it's a lot easier to become familiar with them because there are a lot of them, but still they're broken down into categories, and there are some cases are worse than others in a particular category. And if you know what category you're looking at, you know what the levels of the offenses are and what's required for a particular offense. And that's what the judge has to rule on. You know, a lawyer can bring a motion for a directed verdict or a motion to dismiss at the close of the prosecution's case. And if the prosecution hasn't proved all the elements of the crime, the judge has to know that, because the judge can either dismiss the case right then or let the case go on, especially if it's a jury trial.
Rule 20.
Correct.
It's like nightmare for prosecutors.
Well, it has its place.
Oh, my nose! I want to itch my nose. But anyway, we wanted to say, Angela, thank you. Yeah, Angela said thank you. Very informative. So I want to thank Joel for taking the time out on a Saturday to come chat with me. I just figured, that he practices in there. I mean, we've had a couple hundred cases against each other.
At least.
And we can sit here and not
Well, there's a professionalism that lawyers should have. Not all lawyers have it.
Right.
Not all judges have it. I asked my father one time when he was a judge, I said, it was a silly thing to do. I hadn't really thought it through. And I said, Dad, how is so-and-so up in Tucson as a judge? Oh, he's a great guy, wonderful. And I get into his court, and the guy's a flippin' idiot and nasty to boot. And I'm thinking, okay, why would Dad know what this judge is like in his court? He wouldn't. He's another judge.
Right.
So as far as my dad was concerned, the guy's probably a great guy to go out and have a beer with after the judge's meeting. But he doesn't know what he's like in court. So that was very silly that I even asked him. But I learned my lesson.
Right. So personality.
But Sandy Russell had another question. But a lawyer judge would have to do both?
She's talking about the CLE. We
I
kind of touched on that.
I don't think a judge has to complete the CLEs that a lawyer does. That's not.
No, but if you're both a lawyer and a judge, you would, because you have to maintain your bar license is what she means.
How would you be both a lawyer and a judge?
You keep your bar license, though.
Well, but you don't do CLEs as a judge.
Do they not?
No.
Are those? I wonder if those judge classes count for your bar license. What do you go inactive
I don't.
or what?
What I'm saying is, I don't believe judges. I know Superior Court judges don't have CLE requirements. As far as I know, yeah, and neither do justices of the peace.
Really?
Yeah. It's lawyers that have the CLE requirements.
Right.
So judges may have mandatory training in the beginning.
Do. Yeah.
Okay. But
no, it's constant. They do it every year. Justice of the peace 3 weeks a year.
Okay, well then that's your it's not called a continuing legal education as far as I know, but that is the additional training, just like a lawyer gets, only you get more of it.
Well, and I guess Superior Court judges
I don't think they do 3 weeks.
No, I don't know what Superior Court judges do. I've never been one.
It's changed over the years. Now they get like, I think 3 weeks, but when my dad became a judge in 1979, they had a 6-week training program that was in Reno, Nevada.
Really?
And they go up for like 2 weeks at a time. And then, and of course, the state had to pay for their hotel rooms and the flights back and forth and stuff. But I think it really produced better judges because they were better grounded in the basic rules
Right.
in a lot of different areas. But they don't do that anymore. And that's why, another reason why it's important to have a lawyer as a judge in the justice court is because you are well grounded in those basic rules. Whereas if you're not a lawyer, especially if you have no experience at all legally and you come into a justice court, I'm sorry, but you're going to be pretty lost.
Right. And then with the volume that JP5 has.
Yeah, it'd be impossible.
Well, we're going to go off. We did hit an hour, so we'll quit boring everybody with our legal jargon. But I think it was entertaining. I had fun.
I had fun too.
Yeah, so.
Of course, I like to hear myself talk. I probably talk all the way home.
Me too.
Just me driving.
Yeah, you know how lawyers are.
Yeah.
What do lawyers and mosquitoes have in common?
I don't know.
They're both blood-sucking parasites.
Oh my God. I should, at the risk of, and this is not a crude joke or anything, but at the risk of offending somebody, there was an elderly gentleman that was very wealthy, and he was dying, and he knew it. And he had 3 close friends: his lawyer, his priest, and his doctor. And he made each of them promise. He gave each one of them $1 million in cash. He set it up so that each one could go into his coffin, where his coffin was, the funeral home, and put $1 million in cash in his coffin. He was going to try to take some with him. It was a weird idea, but this lawyer, judge, and priest agreed to do it. And so the guy died, and there was a security guard there that let each one in by themselves. And so they put money into the coffin, and the coffin was sealed. And as they're walking away, the priest said, I feel really guilty. He said, I only put in $750,000. I mean, the orphanage needed a new roof, and it's expensive. And so I feel really badly about that. And the doctor says, well, I'm glad you said something, because the new children's wing at the hospital needs a lot of equipment, and there's repairs needed already. And so I only put in $600,000, and I felt kind of badly, but I'm glad you said something. And the lawyer looked at these two and said, you both should be very ashamed. I'll have you know I put in my personal check for the full amount.
That's a good one. So, yeah, that's how we deal with each other.
Yeah, you got to have a sense of humor.
So, all right. Well, we'll let everyone go. Thanks for tuning in. Hope you have a great weekend.
But I want to say one other thing, too. And just because we get along doesn't mean that we won't try to rip each other's guts out in court.
Oh, no.
But it's done in a civilized fashion, and that's the purpose of court. It is an adversary system. So if Christina is prosecuting a case and I can't convince her that I'm right about something, then we go to trial. And
right.
Then, it's going to go one way or another. But there's nothing to be upset about. I might be upset about how things went for my client. But if Christina's doing her job, there's no reason to be upset at her. She's lying, cheating, and stealing as a prosecutor, meaning she's trying to influence a jury, especially with things that are not admissible, which some lawyers have done. That I don't consider that proper, and lawyers get sanctioned. And the judges or the courts believe it's enough for a judge to tell the jury, gee, you can't consider that. I don't believe that actually works. And sometimes it's so bad that a mistrial is required, which means the trial doesn't count. They got to start over. But anyway, enough of that. And yeah, I did enjoy it. And thank you.
So we banter and we fight our sides, and then we walk away, and we're usually civil after that, handshake or good job or whatever. I guess we can't shake hands anymore, so we'll just have to say good job, air high five or whatever. And
yeah, no shaking hands.
All right. Well, we'll see ya. Have a good weekend.
Thank you.
There we go. Okay.